Probation is a disciplinary action that the board may take against the license of a nurse following one or more violations of the Nurse Practice Act. As defined in board rules, probation is the monitored practice of nursing. One aspect of this monitored practice is the quarterly report provided by the nurse's healthcare employer. In this viewing, board staff in the legal division will provide a review of cases involving substandard practice and diversion, a review of monitoring stipulations found in board orders and agreements, and information about administrative hearings. At the conclusion, you should be able to identify relevant records in preparation for and in response to receipt of a subpoena from the board, and apply monitoring stipulations in an employee's board order agreement to your practice setting. My name is Kathy Bowden. The first case involves substandard practice by a nurse. Our nurse completed an associate degree in nursing from an Alabama program and was subsequently licensed in Alabama as a registered nurse by examination. The nurse had prior experience as an emergency responder and began their practice in the intensive care setting and then the emergency department setting. The complaint came from an Alabama employer who reported the nurse for failure to follow physician orders, misrepresentation of documentation within a patient record, and blatant abuse, neglect of patient care practices. Following the receipt of this complaint, the board's executive officer caused for an investigation by board staff to occur to determine if there was evidence of a violation of the Nurse Practice Act and grounds for the discipline of the license. Upon initiation of the complaint process, the nurse was notified by mail at their address of record that the board had received a complaint and was given contact information for the investigator assigned to their complaint. In addition, an acknowledgement letter was sent to the employer, who was the complainant in this matter. Board staff checked NurseS, which is a database shared by other jurisdictions who participate in that system, and it's a national database where a nurse's license, status, and prior disciplinary action can be verified. Board staff also checked the State Judicial Information System, and a check of that revealed no additional information that the board was not previously aware of. Following this, the board issued a subpoena so that records pertinent to the board's investigation could be gathered. Of note for the subpoena is that the subpoena does request a response within 10 days of receipt of the subpoena. Pertinent records relevant for the investigation of this complaint included employment records, drug screens, relative to any incidents that the nurse might have been involved in, statements from witnesses of any conduct that the nurse might have engaged in, as well as patient care records. In this particular situation, the majority of the records came in when the complaint was received. As you're gathering records, things to consider are that when photocopies are made of the record, that when a highlighter has been used on the record and the record is subsequently copied, the highlighter may actually produce a copy of the record where the highlighted area actually shows as a redaction. Additionally, if you've ever made copies of a record, sometimes you might notice that when the margins are close to the edge of the paper, that the actual copy that's produced may cut off a portion of the record. So it's important to make sure that the records, when they're forwarded, are actually going to be legible records. The other thing that happens when the complaint process is initiated is that the licensee's license status is checked. And in this instance, the nurse's registered nurse license was active for the current renewed license period. and would remain that way, and the nurse would be eligible to renew their license during the course of the investigation if a renewal occurred during the investigation phase. Records that were available for the board to review included prior counseling regarding the nurse's failure to report an infiltration. There were witness statements from a charged nurse and a registered nurse relevant to the nurse's conduct in the work setting. There was a record regarding an interview with a physician and an emergency department record and automated dispensing cabinet report. An independent review of the emergency department record and the automated dispensing record by board staff identified inaccurate documentation by the nurse. In this chart, you can see that the time that the IV started, the time that the IV was started was after the time that medication was documented as being administered intravenously. When the licensee or the nurse had contact with the board's investigator, the nurse actually admitted that they had administered the ordered intravenous medication intramuscularly. So what were the applicable standards of nursing practice for this nurse's practice? It's actually all of the standards of nursing practice that all of us as nurses are accountable for: conduct and accountability, documentation, medication administration, and safety. The applicable grounds for discipline in this case was unprofessional conduct of a character likely to deceive, defraud, or injure the public in matters pertaining to health. Specifically, in this particular case, there was an incident of inaccurate documentation by the nurse. From interview statements, witness statements in the record, medication had been ordered for a patient, but the nurse had told the patient that they would have to wait to receive the ordered pain medication until they returned from x-ray. And there was a failure of the nurse to implement the plan of care as ordered, resulting in delayed, omitted, or care provided contrary to the physician order. Board staff action following the complaint investigation could either be to commence disciplinary proceedings through pursuit of an informal disposition or through the issuance of an administrative complaint. And in this particular situation, the recommendation of board staff was for a possible informal disposition. As such, the case was forwarded for review by the attorney. A consent order was prepared for offering to the nurse. In this case, the consent order would be for probation for 12 months with practice-related requirements, a $300 fine, and relevant courses. Contact was made with the nurse so that an interview could be scheduled, and the licensee or nurse was sent an appointment confirmation letter. At the interview, this is actually the nurse's opportunity to review the board's evidence that has been gathered at this time and to provide any evidence not previously submitted that may alter the current status of the case. Options that are available to the nurse at this time for resolution of the case are the consent order that's going to be offered, an administrative hearing, or the nurse could opt to voluntarily surrender their license for revocation. Whenever a consent order is offered to a licensee or a nurse, it includes an explanation and waiver of rights. Typically, you may not have seen that form, but know that it exists and that was provided to the nurse when they considered whether or not they were interested in the consent order. The consent order is actually subject to members of the board approving and accepted at a regularly scheduled board meeting. The consent order process is actually a 3-step process, and when the nurse is interviewed, this is part of what's explained to them. Step 1, the nurse has to agree to the consent order, so they have the option of either being interested in the consent order or not. If the nurse agrees with the consent order and they sign it, then that's step 1. The next step is that the consent order would be placed on a subsequent board meeting agenda for the board members to consider as to whether or not they're interested in accepting and approving the consent order. If that happens, step 2 has occurred. The next step that the board takes is to let the nurse know what the board's decision was regarding their consent order, and this happens by return of the consent order by certified mail to the nurse's address of record, and the underlying disciplinary action that's in the consent order becomes effective upon the attempted delivery of that document back to the nurse by certified mail. In this particular incident, the nurse actually agreed to the offered consent order, and following their signature on the consent order, they were provided with a copy to leave with. They were also provided with information with respect to where to obtain their courses that would be required in the consent order if it was accepted by the board. And the nurse was also asked to disclose who their present employer was. At this point in time, the nurse is left with a piece of paper. While it's been signed by the nurse, it's still a piece of paper, and the nurse is not obligated to share that piece of paper with anyone at this time. If the nurse chooses to do so, it's actually a good faith effort by the nurse to let the employer or whomever they're showing it to what might happen to their license if the board accepts the consent order. In the interim, the nurse has an active license. If the nurse gets home and has second thoughts about the consent order that they have signed, all they need to do is send something in writing to the board, letting the board know that they wish their consent order to be withdrawn. And as long as that written request is received before the board action, then the board won't vote on it. In this particular instance, the board did vote to approve and accept the consent order, and it became effective when the board had attempted notice of that certified delivery back to the nurse. At that point in time, the nurse's license status was changed to active probation in the nurse's, At that point in time, the nurse's license status was changed to active probation in the board's license management system. This would be a snapshot from the board's website if you went to the license lookup feature and looked up the licensee's license status. In the status box, you would see their status showing as active/probation, and in the discipline box, there would be a Y indicating that disciplinary action had occurred. If you click on the Y, the bottom box is going to populate, and you'll see that the action taken was probation, and it will give you the start date that the nurse's license was placed on probation. If there's no end date, that would show you that the order is still in effect. For this particular nurse, the public record of this case ended up consisting of the consent order that the nurse signed and was subsequently approved and accepted by the board at a regularly scheduled board meeting. There is no private disciplinary action that the board imposes whenever disciplinary action occurs. Following the board's action, the board complied with reporting requirements, and the discipline was reported to the Healthcare Integrity and Protection Data Bank, which has now been consolidated with the National Practitioner Data Bank, or the Data Bank. And this particular data bank is a compilation of information relevant to healthcare practitioners that provides an opportunity for review of the individual's credentials. The board also reported the discipline into Nurse S and followed up by sending a memorandum to the complainant, who was the former employer, so that they would know what had happened with their complaint. And a memorandum was sent to the present employer that the nurse had identified. And in this particular instance, the employer was a subscriber to the board's website, and they received notification of the action through the board's subscription service. Our next case review will be a case involving diversion. As Ms. Bowden has already pretty thoroughly covered evidence gathering process in her review of a substandard practice case, we'll now take a look at a couple of case studies that deal with diversion. My name is LaDonna Patton, and I'm a nurse consultant in the legal division at the Alabama Board of Nursing. We're also going to do a very basic review of the three components of a consent order, which is the process by which the board delivers the majority of its discipline. In this first case review, you'll find that this is the findings of fact, and that'll be detailed in the consent order.
The facility reported this nurse that worked in the ED, had been an RN for 4 years. The facility began an investigation when a Demerol ampule top that was suspected that was found in an employee restroom. The nurses were advised to ensure that their charting was complete by the charge nurse, who then ran a usage report. When the charge nurse returned to the nursing desk, the RN had left a note stating that he did not feel well and had left to go home. At the time that he nursed, there were 3 patients assigned to that nurse. The audit revealed that he had failed to account for 111 milligrams of Dilaudid and 1,750 milligrams of Demerol on practically every day that he had worked during a 30-day time period. The board's investigation also revealed that he had failed to disclose an alcohol-related arrest on his initial application for licensure, even though the arrest had occurred approximately 8 years prior to his application for licensure. So the Nurse Practice Act violations are detailed in the consent order under the conclusions of law section. This nurse was charged with being unable to safely practice nursing with reasonable skill and safety to patients, abandonment, of course, for leaving the workplace while patients were assigned to him, misappropriation or diversion for not accounting for medications that he had accessed and removed, inappropriate or unprofessional conduct or behavior in the workplace, and failure to practice nursing in accordance with standards adopted by the board. And these standards relate to documentation, controlled drug record documentation, and facility policy and procedures, because the majority of facilities are going to have policies and procedures or guidelines regarding accounting for controlled substances and medication documentation. The second case involves an LPN that had been a nurse for about 17 years and was licensed by endorsement into Alabama because she was initially licensed in Mississippi. This nurse worked in an assisted living facility, and her accounting for controlled substances came under scrutiny whenever it was noted that she did not document administration of medications that she had signed out on 4 different residents' narcotic records. These medications included oxycodone and hydrocodone. A urine drug screen was requested after that chart audit, and she had a positive urine drug screen for oxycodone, and we'll address urine drug screens on a later slide. All of this information, along with her prescription profile, was detailed in the findings of fact section of the consent order. The board subpoenaed her prescription profile and found a routine prescription for hydrocodone. The nurse tried to explain the positive drug screen by stating that she had received a medication from her cousin, but she was consistently signing out more medications than other nurses when compared to her peers. So in this case, the conclusions of law, or the Nurse Practice Act violations, included that she may be addicted to habit-forming drugs to make unsafe or unreliable, that she may be unable to safely practice nursing with reasonable skill and safety to patients. Again, she failed to practice nursing in accordance with standards adopted by the board according to documentation and controlled drug record documentation, misappropriation or diversion, and in this case she was also charged with testing positive for unauthorized drugs or substances. Other things that she was charged with included failure to administer medications in a responsible manner and demonstrate competence in administering or carrying out patient care. She was also charged with engaging in the personal use of unauthorized substances because she did not have a prescription for the oxycodone for which she tested positive for. So what happened in these 2 cases? You'll see in both instances there was a consent order that was offered to both of these folks. The consent orders both included a suspension until completion of required comprehensive evaluation and treatment if recommended, followed by reinstatement on probation for 60 months. The fines did differ, and if they were not recommended for treatment, a time period of reinstatement on probation also differed, as did the fine. So where are these nurses now? The first nurse is actually revoked. He ultimately ended up surrendering his license after being suspended for about 1 month. He did complete the evaluation and was recommended for treatment and was either unable to or unwilling to complete the treatment at that time. However, he had signed the consent order about 2 months before it actually took effect. He was employed during that time period. The second nurse is still suspended and remains suspended and will stay that way until January 2014 if she does not complete the requirements to lift the suspension. At that time, if she has not done that, then the license will automatically revoke based on one of the clauses in the consent order. Now, occasionally, there may be an option that the nurse could be released following 36 months of probation if they were initially ordered to do 60, and that's going to be specific to the order, and you should read those various stipulations. So what if the nurse had been ineligible for a consent order or had declined the offer for a consent order? This case would automatically go to a hearing. So in case number 1, certainly the note that the nurse had left indicating that he was leaving the facility, that he didn't feel well, would be helpful for the prosecution of the case from the board's perspective, as would any proof that he had assigned patients at that time, such as patient records, an assignment sheet, patient tracking information, something to substantiate that he did leave his assigned patients. Additionally, the charge nurse may be called upon to testify. As for the large amount of unaccounted for controlled substances, however, that may be able to be testified to by the board's nurse consultants if adequate information is given to review the records. In the second case, the nurse consultants can typically testify to the information that was given in that type of case. In either case, though, if the nurse exhibited signs of impairment such as slurred speech, stumbling, forgetfulness, or a significant failure to perform work duties as assigned, such as sleeping on the job, staff that witness that behavior will typically be called upon to testify at a hearing. This is a snapshot of what an order section would look like of a consent order. So you would have a findings of fact section detailing the facts of the case, the conclusions of law, detailing the Nurse Practice Act violations that were identified, and then the order, which specifies what the nurse has to do in order to complete the terms of the order. There are multiple numbered stipulations that follow this, and you'll see on this specific example, which would have been used in the previous 2 cases, the license was suspended until they completed various stipulations and then would be reinstated on probation for 60 months. Typically, there is an option to be released at 36 months, but that may not be the case depending upon the order. And there is also a section that says if they were not deemed in need of treatment, then the probationary period can differ. Could be 12 months, 24 months, 36 months. It just depends. And so you, as the employing facility, would need to understand the order. The final 2 sentences do detail the automatic revocation section, that the suspension can extend no longer than 12 months or else the license does automatically revoke. So nurses can and do sign these and are still employed. They are not required to share these with the employer until it takes effect. And so, as noted in one of the previous cases, a nurse had signed a suspension consent order and is now revoked and was employed for an additional 2 months. So, what should you do if you think that you may have a case of diversion? Certainly, drug screening is an option. The board is not mandating drug screens, but if the facility chooses to drug screen, then using a drug screen that's legally defensible is certainly beneficial to the board's prosecution of the case. A chain of custody drug screen is certainly preferred over the in-house non-chain of custody drug screens. Being sure that the drug screen actually screens for the drug in question. And if it is a random or reasonable cause drug screen for suspected impairment, please note that as well. And what are the behaviors for the suspected impairment or reasonable cause? Other information, witness statements, especially, again, if it's suspected impairment, anything that is gathered through the facility investigation certainly could be shared with the board's investigation as well. And any record substantiating a failure to account for medications, such as facility audit notes or automated drug dispensing cabinets and paper-controlled drug records and patient care records such as the MAR, nurses' notes, and pain records. Other records that the board may look at would include personnel records. It's possible that there are instances of employment fraud that's also found during the employment application fraud that's also found during the course of the board's investigation. For the drug screens, if a nurse screens positive for hydrocodone, they may have disclosed that they take a medication with hydrocodone in it. That is not necessarily proof positive that the nurse did not divert the medication if you have concerns about hydrocodone accounting. However, during the board's investigation, some of the records that may be obtained include prescription profile, and the board would certainly be looking at things such as multiple prescribers, early refilling, and any other pattern that might indicate a concern for diversion and substance abuse. The next section is going to be the monitoring.
My name is Mariette Davis. I'm also a nurse consultant in the legal division. I am the director of the Voluntary Disciplinary Alternative Program, or VDAP. The other nurse consultant in the legal division is Dawn Daniel, and she is the director of probation monitoring. This is where the nurses who have disciplinary action that requires some kind of monitoring go after they've had their disciplinary action or they have signed their VDAP agreement for monitoring. Between VDAP and probation, we have somewhere around 700 nurses that are monitored. That sounds like a lot, but we only are dealing with less than 1% of the over 85,000 nurses that are licensed in Alabama. One of the first things that we try to do, if we have a complaint that is received at the board or someone self-reports for something that's a possible impairment issue, like drugs, alcohol, mental health issues, or some physical illness issues, we try to make sure that they are considered for eligibility in VDAP. The full criteria for the program are found on the board's website under the tab for the alternative program. One of the stated purposes of VDAP is early identification and referral for treatment for people who have impairment issues. So one of the ways that we try to protect the public is to get people out of practice quicker than they might otherwise leave practice if they have to go through the disciplinary process. Usually VDAP cases are closed in a shorter period of time than disciplinary cases. Two of the criteria that deserve mention here are that the nurse has to admit they have a problem and request participation, and the second one is we tell them they have to cease nursing practice immediately. And so in that way we try very hard to get them out of the workplace. There are some reasons that nurses may not be eligible for VDAP. One of the common reasons is that they have had some kind of disciplinary action for any reason in either Alabama or some other state or jurisdiction. Also, if they have pending felony charges for any reason. If someone is arrested for trying to obtain controlled substances by fraudulent means, like they're calling in fraudulent prescriptions and picking them up, those are felony charges if they get arrested. If they have a past felony conviction, they're not going to be allowed in the program either. The third one, board staff determined the nurse probably won't benefit from the program. One of the things we're beginning to see now, after almost 20 years of monitoring people in the alternative program and then disciplinary monitoring before that, is that people have maybe been through the alternative program a couple of times and successfully completed it. and now they're calling back and wanting to be in the alternative program again because they've relapsed. There comes a point in time where you have to think that the alternative program probably is not the avenue they need to take. The other thing that happens is that the nurses are uncooperative in the process. They don't follow the instructions about getting evaluated or going to treatment, or they leave treatment AMA. Also, eligibility is a process. We may think in the beginning they look like they're eligible, but something may happen that says, no, you're not eligible later on in the process. In comparing nurses monitored in VDAP and probation, I think a couple of things are important for people to keep in mind. In VDAP, this is not disciplinary action. I talk a lot to supervisors or employers that say, well, I looked up so-and-so and they didn't have any discipline. Well, they're not going to. It says active. It does not have any kind of disciplinary designation. In VDAP, their records are private, but they are not confidential until they successfully complete the program. We don't publish the names of people who sign VDAP agreements. VDAP is also an option only for impairment issues, for practice violations, unprofessional conduct, those kind of things. That has to go through discipline. Also, there are no reports that are sent to the data banks for nurses that sign VDAP agreements. On the other hand, in probation, it is disciplinary action. Their licensure status is going to say active/probation. Their records are a matter of public record. And their disciplinary action is reported to all the data banks, and it may be forwarded to the Office of the Inspector General. The VDAP agreement is also effective on the very day it is signed. When somebody comes to the board office and signs a VDAP agreement, when they leave, they are being monitored. On the other hand, in probation, discipline is only conducted 6 times a year on the second day of the 2-day meetings that are held in January, March, May, July, September, and November. The orders are sent out on the Monday following the discipline, and the orders are effective upon service or attempted service to the nurse by certified mail no later than a week after those orders are sent. This means that a nurse can actually sign a consent order several weeks before it actually goes into effect. The monitoring of substance use disorders, once a nurse gets to either VDAP or probation, the monitoring is very similar. In timed work and nursing, employment restrictions, the employer's responsibilities, controlled substances restriction, drug screening, and the nurse's expectations. The main difference in VDAP and probation is the way the nurse arrives at the monitoring. For timed work in nursing, everyone who is monitored by the board has to work in a nursing job, one that the first requirement is an active Alabama nursing license for at least 18 months for VDAP. In probation, you need to read the order very carefully to find out about the required time in nursing. It might be 18 months, but it might be something else. Also, nurses are required to work at least 96 hours a month for that month to count toward their requirement. This is a little bit more than half-time. Most of the nurses in VDAP end up working full-time anyway, but if you have somebody that's part-time, you do need to sort of monitor that and make sure that, or try to see that they get 96 hours a month. We also don't allow them to work a bunch of overtime. They can work 80 hours in a 2-week period if you use something other than 12-hour shifts, or 84 in a 2-week period if 12-hour shifts are used. We don't object so much. We happen to know that a shift doesn't always end at a particular time. I mean, that's the nature of nursing work. So we certainly want the nurses to finish their work. But what we really object to is scheduling of extra shifts that would be overtime. There are some employment settings that are not appropriate for monitored nurses. The fact that a nurse is monitored should suggest that there are some sites that are not appropriate for a monitored nurse to work in. They may not work in areas where there is no supervision, erratic supervision, inconsistent supervision, or they're expected to function independently. We have listed several things that are not appropriate work sites for monitored nurses. Another word is that monitored nurses should not be employed as faculty members for schools of nursing, and that includes clinical associate positions. We get a lot of questions about on-site monitors. Basically, the on-site monitor for a monitored nurse needs to be someone who has a license as a health professional in good standing with their professional regulatory board. Okay? This means a nurse in VDAP is not supposed to monitor a nurse in probation, okay, or the vice versa. LPNs cannot monitor or supervise RNs. There are lots of other options for that, and we've listed several of those. The monitor is not really a preceptor. It doesn't need to be like that. They don't necessarily have to be on the same unit, but they do have to be under the same roof when that nurse is working. And they have to be available in case the nurse needs some intervention. The on-site monitor needs to be identified by name on the notification of the receipt of the order or the agreement. They also need to be physically present under the same roof at the same time with them being monitored. They cannot be available by telephone, and they really kind of need to work about the same hours as the monitored nurse. What are employer responsibilities with monitored nurses? First of all, you need to complete the notification of receipt of the board order or agreement when the nurse is employed or returns to work. Please read their agreement or order. There is no substitute for knowledge about what is in it. Also, the direct supervisor really needs to have a copy of the agreement. There are times when Human Resources wants to come in and take the agreement and file it. That's fine if they're the repository for records, but you need to have a copy made so that the direct supervisor has access to that, because that's who is supervising this nurse and needs to know what their restrictions are. If you have any questions about any of the information you receive, or if you just really aren't familiar with this whole process, then call the board staff member that is identified in all of your information that you're given about the monitoring. It's always going to list me or Dawn as the person to contact. Another employer responsibility is to choose an appropriate supervisor and or monitor for the nurse. I get lots of these notification forms back where the supervisor and the monitor are the same person. Now that works if you're working about the same hours, but if we have a supervisor that's working Monday through Friday, 7 a.m. to 4 p.m. or something, and this nurse is hired for the weekends, you are going to have to name somebody to be the monitor. There is no way that you can adequately monitor this person if you're not even there. So that's one of the things that really needs to be looked at. You need to submit reports to the board on time. These reports are now submitted online, and therefore the nurses will be asking for you to supply your email addresses to us so that we can get all of those things set up for you. You also need to inform your board contact if there are problems with their performance. This does not mean that you tattle on everything or it gets them into a lot of trouble. We just need to know. If they have some kind of conference or counseling or something like that in the workplace, we do need to be aware of that. Lots of times we will get report after report where the supervisor or the monitor is saying what a wonderful nurse this person is and how fabulous they are, and then all of a sudden they're terminated. And then we find out that they weren't so fabulous, but they didn't tell us any of the stuff that wasn't so great. We really need to know this information. When the supervisor or the monitor changes, you need to notify your board contact. This is especially important now with the online monitoring. If we don't have the right information, then you're not, the person who's the supervisor is not going to get the reminders, and they're not going to have access to do the report. We also need you to report the actual time per month the nurses work, not just the scheduled time, because we have to keep up with the actual time that they work for counting it toward their requirement in working in nursing. When it's time to review the nurse's controlled substances restriction, if you are mailed documents about that, then you need to send them back to us in a timely manner. The other thing that you as an employer really need to do is to make sure that this nurse with a controlled substances restriction is blocked from accessing these medications. Almost all of the computerized systems have the ability to do this, and you need to make sure that it is done. Make sure you talk to the pharmacy about it, get them to check it, etc. It's very important to do this. How do you supervise these folks? I think that's a fair question. In the beginning, I think you need to have frequent contact with them, meet with them, make sure that they're getting what they need and that you're getting what you need from them. You need to be visible to your staff and to the monitored nurses. Involve them in chart and narcotic audits. Make sure they see what you're checking and looking for. You need to perform drug screens on the monitored nurse the same way you would any other employee according to your facility's policies. If you think there's something funky going on, but you don't have the documentation that would warrant a 4-cost screen, you can always call us and we can drug screen them. You need to be vigilant but not paranoid. There's a really fine line there, but you do need to be vigilant about what you're looking at and watching the nurses that are working for you. If you have questions about things, Dawn and I have worked with problem nurses for years, and we can guide you through some of that process, ask you some questions about things, and try to help you with that. That's part of what we're here for. Most of the nurses on a substance abuse or substance use disorder order or agreement will have a controlled substances restriction. This is a minimum of 6 months of their employment once they return to work in a job that requires a nursing license. Some nurses do not have this restriction. You need to look at the order or the agreement closely to see this. The privileges are restored only when you and the nurse receive notice from the board that the restriction is lifted. Now, what does this controlled substances restriction mean? Basically, the nurse does not need to have anything to do with controlled substances while they have this restriction. We have outlined all of these things on this slide. They should not be accessing or signing out medications that are controlled substances, witnessing waste, administering these drugs even if somebody else signs it out. They do not need to be documenting controlled substances that are given by someone else. They don't need to count or verify narcotics. They don't need to phone in orders for controlled substances. They don't need to pick up any controlled substances from the pharmacy, and they just don't need to deal with it. Now, a lot of employers consider this restriction really an issue, and I agree that it can certainly be inconvenient. However, it doesn't have to be as bad as it could be. One way is for the supervisor to be proactive. I don't think just having the nurse go and find someone to give medications for them is the best idea. Maybe you need to assign it to different people at various times. I think when it's clear from the beginning who is supposed to be giving the controlled substances, that makes it easier on everyone. The duration of the agreement, these nurses are going to do drug screens with our third-party administrator, and that is First Lab. This is a nationwide company. They have collection sites all over the country. The cost varies from about $50 total per screen up to about $100 for urine drug screens. If they have to do hair occasionally, that's close to $220 for a screen. We do screens Monday through Saturday, and their screening frequency is random. If they have a positive screen in probation without a prescription, they get a new case, an evaluation, and a $1,000 fine. In VDAP, they have to stop practice. They have to notify their employer of a positive screen. They get to go for a relapse evaluation and probably sign a second agreement. If there is a positive screen, I always send a letter to the employer about the positive screen. You may, again, conduct random and for-cause screens as your facility policy allows. What are the expectations of the nurses who are monitored? First of all, they need to disclose their monitoring in the employment interview process. There's no way around that. You need to know about it. They also must supply a copy of their entire agreement or order upon employment. We've had cases where people would not give them the first couple of pages that said all the things they had done wrong to get into trouble, and they only handed them the order part of it. No, they need to give you the whole order or agreement. They also must inform coworkers of their restrictions as appropriate. There is no realistic expectation that they are going to have anonymity in the workplace. Every now and then I'll get someone that says, but I'm supposed to be anonymous in the workplace. No, you're not. That's for your 12-step meetings. It is unrealistic to think that a nurse who cannot give controlled substances can remain anonymous. There are only so many reasons that you can't give controlled substances. On the other hand, the nurse should not be required to disclose to everyone in a public forum why they're in trouble. That needs to be done on a case-by-case basis, but they cannot keep it a secret. The other thing I hear occasionally from employers is that they feel like the monitored nurses are always demanding something. They need all of these scheduling special requests and all that. They should not make unrealistic scheduling requests. I do expect some accommodation from their employers for them to go to their aftercare or continuing care meetings. These meetings are only once a week, and they typically don't have a lot of choices for when they can go. However, they should not ask you for special accommodations for their 12-step meetings. There are plenty of those around, and they should be able to figure that out. The probation orders that are basically until the conditions are met, they have a fine, usually a course, and then there's the requirement for the notification of receipt of the order from their employer. If they have a timed probation, typically it's 12 months, 24 months, or 60 months. They have a fine, they have some courses, they have to get the notice of receipt from the employer, and then they have monitored practice also. If they have suspension until the conditions are met, there's a fine, there are courses, and also a notification of receipt from the employer. And if they have suspension until conditions met followed by probation, they have an evaluation, a fine, the notice of the receipt from the employer, and monitored practice. When should you call probation and VDAP? Anytime you have a question about their monitoring. We will be happy to try and answer your questions as best we can. That's part of why we're here. The quarterly reports are online, and email is a great way to communicate with us. It's sometimes much easier for me to reply to an email than it is for us to play telephone tag for 2 or 3 days. Anytime there's a change in the supervisor or the monitor, anytime the person has a positive drug screen at work, if there are practice issues that have come up, or if you terminate the person's employment. We've also included, as the last 2 slides, a flow chart it's about the discipline process and the monitoring flow chart. The first page covers the complaint or self-report and goes through that process and shows how the processes differ some. If the person is determined eligible for VDAP, they go through a much shortened process. If they're not eligible for VDAP, then they have to go through the investigations where the evidence is gathered. Then they review the evidence that's there. It goes to the legal nurse consultant and the attorney. If there's sufficient evidence, then there's some discipline that happens. If there's not sufficient evidence, then the case will be closed. The second page shows the monitoring process, which is the same basically for VDAP and probation. We have included our contact information for both Kathy and LaDonna, and Dawn and I have included our phone numbers and our emails. We have included all of our contact information there for you. Thank you.
My name is Patrick Samuelson. I'm the Assistant General Counsel at the Board of Nursing. My job is to draft and prosecute disciplinary matters, and today we're going to discuss administrative hearings, the participation of CNOs and nurse managers. There are many reasons a case could go to a hearing. Specifically, the conduct is so severe that an consent order may not be offered. This could include something as simple as a felony that's very new and very severe, or very convoluted employment matters that prevent the board from being able to offer a consent order. Another issue could be that the nurse comes down to the Board of Nursing and then declines a consent order. This happens after the process of interviewing with the nurse consultant, reviewing the order, and then determining that it is not what the nurse wants to do. Occasionally, a case will go in front of the board, who then decides, after reviewing it, that the board is no longer willing, or is not willing to accept the offer that's been made. This happens, the board sometimes can counteroffer or might require that the case go directly to administrative hearing. Another unfortunate consequence of a consent order having to go to an administrative hearing is if we cannot contact the nurse. This happens when a nurse does not have recent contact information with the board, so that we can't contact and we have no other option but to take it to administrative hearing. This is unfortunate because oftentimes these issues are not so severe that a consent order couldn't be offered, but because of lack of contact, we have no other option. As an employer, you may never know why the case went to administrative hearing due to confidentiality matters. Reasons you and your employers may be subpoenaed to testify at a hearing. You could be the custodian of records that are needed to identify the records, photographs, or facility investigations. Oftentimes, you'll be needed to explain the procedures and policies of your facility. There could be a situation where the nurse has discipline with your facility, and therefore you would have to come down and explain these matters. Sometimes there's just personal knowledge of the facts that can come from no other place but you. Therefore, you would need to come down and discuss these matters. A subpoena will be clear as to what the board is expecting in these documents. Oftentimes they can be urinary drug screens, they can be employment evaluations, they could be counseling reports. But the subpoena will say when it's expected, to whom it needs to go, and also what documents are expected. A subpoena will be issued upon the initiation of an investigation. The board issues a subpoena for the records that are necessary to properly complete an investigative complaint. This is because the board has to make sure that we have all facts to be considered before making a determination. Subpoenas could also be issued if you are required to come down for a hearing. This happens if you need to be a witness or have other unique knowledge of the documents. The board will also issue subpoenas for documents or witnesses at the request of the nurse being investigated. This will happen if the nurse asks the board to send out subpoenas to get documents that may support her claim or his claim, or have a witness that can come down to testify as to the matters being prosecuted. Timing of a hearing requires that the board give the nurse a minimum of 20 days notice prior to the hearing. This allows the nurse to have a time to review and also to meet with the Administrative Procedures Act. Hearings may be rescheduled for any number of reasons, including the availability of a witness. So if you were requested as a witness, it is possible that a hearing would be rescheduled if we were unable to find a way to have you come down to testify either remotely or at the Board of Nursing. In preparation for a testimony, The board's not going to sit you up there and say, hey, look at these documents and go ahead. We're going to sit down beforehand and make sure that you know what the case is about, know the documents you're going to look at, and are confident of the records contained in those documents. Specifically, you'll review exhibits ahead of time. You'll discuss the possibility of topics and testimony of the board's attorney or attorneys. You may be contacted by the nurse's attorney. The board does not prevent this from happening, and the board does expect you to cooperate with the other nurse's attorney. You may seek the advice of your facility's attorney at any time, either for board questions or opposing counsel's questions. And the things to remember about testifying: always tell the truth. Don't speculate, and don't try to suggest that you know details that aren't actually there. And this would be called filling in the blanks. And remember, answer the questions you're asked. There's nothing worse than going on a tangent when that's not the question that's happened. There's too much information that's given out that it was neither relevant nor pertinent to the situation. And if you don't understand the question, ask that it be repeated. Don't presume to know what was being asked. A statement of charges is the formal document that's sent out to the nurse prior to an administrative hearing. This describes the factual allegations that the board believes that the nurse committed. The statement of charges also describes the violations of the Alabama Nurse Practice Act and the Alabama Nursing Code. These will be listed in specific codified sections with little bit to no explanation as to what they are, although it is described in detail in the codified rules. The burden of proof is on the board to prove the allegations of the statement of charges. The board's burden of proof is substantial evidence, which is a lower burden than the more commonly understood criminal standard of beyond a reasonable doubt. The board proves its case through the admission of evidence and testimony of one or more witnesses. There are no criminal consequences in ABA hearings. Any resulting discipline imposed by the board rests solely on the nurse's license and does not have any other outlying implications. It's not necessary that you'll have to come down to the board to testify. Oftentimes, the sole purpose of your testimony is to identify documents that the board may be able to have you certify by an affidavit that are accurate copies to avoid personal appearance. This will happen through the subpoena. When you receive this, it is important that you send down the signed, certified copies at a reasonable time so that the board may have these, as this could prevent you from needing to come at all. If you are unable to travel, the party has requested that you be subpoenaed and may ask the hearing officer to allow you to testify by telephone. This is entirely within the hearing officer's discretion and may or may not be granted. What happens at the actual hearing? Hearings are typically fairly informal and happen at the Board of Nursing's conference room. They are transcribed by a court reporter, and they're held before a hearing officer where witnesses still testify under oath. Whoever subpoenaed the witness will ask the first questions. This is called direct examination. The nurse and his or her attorney, if there is an attorney, may ask the witness questions. This would be called cross-examination. The hearing officer may also ask questions to fill in any holes he believes in order to have a complete record and understanding of the facts and discipline being alleged. Typically, witnesses are not allowed to watch other witnesses testify in order to preserve their own observations of the case. Once the hearing is complete, the record closes and no supplemental information will be considered. This is to prevent the case from going on forever. Once the hearing officer is adjourned, there is no evidence that will be admitted either through the board or through the nurse or nurse's attorney. If you are asked to come down to the Board of Nursing to testify, you will be reimbursed. Mileage specifically is reimbursed. Please document your mileage, as you will be asked to complete a reimbursement form at the board office. And depending on how long you're here, you may be eligible for a meal and or reimbursement. If you're required to stay overnight to testify, you should contact the board beforehand so we can make arrangements for overnight travel to determine if it will be covered. The outcome of the hearing. No decision is made that day. The hearing officer makes recommendations to the board, and then the board makes the final decision after reviewing the transcripts, exhibits, and the hearing officer recommendation. At that point, after the board has made its decision, the nurse can appeal and or ask for a rehearing. Notification of the outcome of the hearing. This will be sent by certified mail. It will go to the complainant, to the respondent, the nurse being prosecuted, the current employer if known, to all the data banks that have been previously described, and other boards of nursing if the board is aware that the respondent is licensed in other states. So in conclusion, disciplinary cases can be time-consuming. The board has to meet its responsibility of fully investigating an alleged violation of the Nurse Practice Act before it can move forward. This may require that you provide documentation or testimony in an administrative hearing. After a hearing officer will make a recommendation. The board then makes the final determination. After the board's final determination, the proper parties are notified, and at this point, the nurse can appeal or request a rehearing.